Hello, if you're in the waiting room waiting, my name's Kevin Carroll. I'm the executive director, and we'll probably start at around 10:03 or so. Just one minor notice, our speakers are going to be audio only. So you won't be able to see them on their camera, but that's okay. So we're just waiting for folks to get here. And again, we'll start probably around 10:03, usually the time we start these 10 o'clock webinars, just to make sure everyone is on. Just want to make sure our two guests are still on audio.
We're Monica here.
And Karine? Fantastic.
Yes.
So I'm going to assume both of you are working remotely.
Who isn't?
We are.
You know, the governor, you know, they keep on announcing the things that are opening up, and it never gets to the level of things that I really want to open. It's, you know, the governor comes on and says, okay, I've got some good news. We're going to open up archery practice and motorcycle training facilities, and then goes down the list, and it never gets to the point where it's, you know, hair salons or movie theaters. So it's always interesting to see how the opening up always seems to hit everything but the things we need.
Very true.
But we'll get there. You're just signing on. We're waiting till about 10:03 to start our webinar. We have folks coming online. We'll be starting here in a couple of minutes. One of the questions I've been asking as we get to jump on these webinars and some of the web meetings, and I'll ask you guys as well before we start. Tell me about a purchase you made that you probably wouldn't have made without this pandemic crisis. Something you bought. How about you, Monica?
I mean, I'm probably, gosh, let's see, that's a great question. I would say probably more wine than I typically would purchase.
No. Great.
Like that one. I purchased a pasta maker.
Oh, that's
there you go. That's the one.
And we've been making pasta every Sunday.
That's good.
I bought a Lego kit, which is the first time I've ever bought a Lego. I have a 17-year-old. I have a high school senior here at home. And we bought the architecture series. We bought the San Francisco skyline and put it together.
Nice.
That's fun.
Yeah, that's a good one.
How long did that take?
You know, it took a couple of evenings. We didn't do it all at once,
Yeah.
but we'd never done it before, so it probably took us a lot longer.
Fun.
How's your senior handling senioritis in quarantine?
You know, they're disappointed. I mean, a lot of the things we went through, senior prom and everything else, they're just not going to go through. And they've accepted it, right? And so, you know, I think she understands that a lot of people are a lot worse off, and that we just have to deal with it. And I think I'm very proud of her. She's doing really good. But I mean, they're obviously you know, deeply disappointed. All these things on TV where the stars, you know, the famous people get up and talk, that doesn't do, I mean, that, at least for my senior, that's not doing anything, right? So,
right.
Yeah.
Everyone likes to help, but, you know, I'm not sure what the answer is.
Right. No, they'll always remember this for sure. And she's got a good attitude. It's, you know, it kind of puts in perspective of things that are truly important, right?
Yeah.
But yeah, but it's certainly tough. Yeah.
For those of you logging on, we'll start here in a couple of minutes. We're just waiting for people to register. We typically start around 10:03, 10:05, not much after 10. We just want to give people time to jump on the call. So I'm just chatting with the host as we begin. You know, one of my projects this week, and I failed miserably, and if anyone's on the listening can give any advice, companies are looking for nurses to come in the morning, do temperature checks and wellness checks.
Oh,
And I was trying to find a way to access, ironically enough, there are a whole bunch of unemployed nurses because, you know,
Right.
elective surgery and regular doctor offices aren't open. And I was trying to figure out a way how to access those nurses to make some money and to help some of our companies. And I just ran up against a lot of walls trying to figure that out.
That's a really good point.
Interesting.
I have heard of the same friends that are nurses that are not working right now.
Yeah, there's got to be
But I'm
some
still working on it.
placement, some companies in town that place nurses. I wonder if they have.
Yeah, I think that's where we're gonna have to go.
Yeah.
I was hoping there's such a huge commission on some of those. I was hoping to kind of bypass and get more of the money in nurses' hands, but there may not be a way to do that.
Yeah.
Right.
Who knows? They might be willing in these unprecedented times to waive that fee, you know?
Yeah.
From a good Samaritan perspective.
And it's for those of you signing on the call, we're gonna start here in a couple of minutes. We're just chit-chatting with our host. One of the things that companies are saying is, you know, yes, we want to make sure our employees are healthy, but it's also confidence, right? They need confidence to come back to the workforce, and having, you know, a nurse there doing a wellness check and of course, you know, one of these, right, is going to help on just making people more confident about returning to the workplace.
Absolutely, that's a good point. It kind of legitimizes it. Yeah.
I'm sure as a top legal employer firm here in town, you're getting a lot of calls from your clients asking about different issues regarding the returning to work.
Absolutely. Yeah, and internally, we're obviously looking at that as well. And being a global firm with offices around the world, it's been interesting having those conversations with you know, with our partners to see how they've managed it. And then some of them, you know, it worked. Others, they had to stop and scale back. And so it's definitely been an interesting exercise and analysis. And even within the U.S., right? Each state is so different of how they're approaching it. So but all of this does play into immigration issues for sure that we'll talk about today.
Yeah.
But the confidence is a big one, right? Even when you think of schools, and there's definitely a lot of discussion with the school districts of how, you know, how to set up the schools back in session in the fall, and they've been sending out surveys, and there's definitely a lot of questions surrounding the comfort level and what everyone is open to trying out.
The school's opening. We're going to start in just a couple minutes for those of you signing on. So, you know, one of the issues that I've been talking to our elected officials and others are, you know, the need to accelerate not opening schools. I think we have to find a solution for that, but just finding some place to keep the kids occupied while their parents are trying to work, right? And this really cuts across socioeconomic lines. So it's not just lower income workers and middle income, it's also higher income and everyone in between. And so just really trying to figure out, you know, how because all the camps are closed, they're not, you know, you can't sign up, and, you know, it used to be math camp or horse camp or, you know, whatever, turtle training camp or whatever that is. You know, we got to find a way to keep the kids occupied so the parents can return to the workforce, whether that's, you know, at home or actually going to an office.
Definitely.
Absolutely.
All right, let's go ahead and get started. Sara, if you want to hit the record button, we can start recording.
We're set.
Okay, we're going to go ahead and start. Hello, my name is Kevin Carroll. I am Executive Director of Tech San Diego. You can see our website at techsd.org. If you're on the call, I'm going to assume you know at least a little bit about Tech San Diego. We've been doing a series of webinars surrounding, as everyone, surrounding the COVID-19 crisis, and we've hit a lot of different parts of it. We've hit leasing, we've hit supply chain, and this is one that I've really been looking forward to. Really the impact of COVID-19, nowhere have we seen a bigger impact than on immigration. You know, whether that's people that are waiting overseas to come over, or, you know, this administration's tact about how they're treating immigration. And there's been just recently some new disturbing information on what may happen on H-1B visas. I'm sure we'll touch on that. But I've really been waiting for this one to really find out what's going on. We read a lot in the papers. Fragomen is a global leader in both employment law and immigration. I've known them for years. They're really the go-to firm in town, not only in town, but again, a global firm on immigration. And we're really lucky to have two of their leaders here. So here's what we're going to do. I'm going to introduce the two executives from Fragomen. They are going to be audio only. They will not be on the webcam. There is a question function. I will be tracking the questions, and most of the questions we're going to go ahead and wait and do those at the end. So feel free to do your questions anytime, and we'll be looking at them. If it's really necessary to interrupt them, I will make a judgment call on that. Chances are I probably won't. So your question will be answered. Just be patient, write it out, and I will get to it. So let me read a really brief bio on the speakers. And this conversation is going to be led by Karine Wenger. Karine serves as corporate immigration counsel to a wide range of clients, from small domestic entities to large multinational corporations in varying industries. She manages a growing legal team of attorneys and paralegals that provide cutting-edge immigration solutions to corporate clients and counsels them on all matters of U.S. immigration and nationality law, regulation, policy, and compliance. So that's Karine, and Karine's going to be assisted by Monica Gilia, and Monica is an associate in the San Diego office working alongside Karine, where she assists individual and corporate clients with the filing of PERM applications, employment-based non-immigrant and immigrant visa petitions, adjustment of status applications, outstanding researcher petitions, and extraordinary ability petitions. So between the two of these, everything you're always going to want to know on immigration. With that, I'm going to turn it over to Karine, and I'll be monitoring the questions. And I'll put myself on mute, and so you don't have to look at me this whole time as well. So Karine, it's all yours.
Great. Thank you, Kevin. Thank you, Tech San Diego, for hosting this event. Welcome, everybody. Pleasure to have you on. If you're joining us for the first time, I thought maybe I'd give you a bit of background about our firm. Founded in 1951, the firm has been meeting needs of clients and moving their workforce around the world for nearly 70 years. We continue to grow and be innovative in meeting our clients' needs as they have changed over time. We have about 50 offices around the world, and we're strategically placed where our clients need us, and we continue to increase our global footprint as they continue to expand as well. Over the years, we've worked with clients through natural disasters, environmental catastrophes, economic crises, and now, of course, pandemic COVID-19. As leaders in this space and in such time of uncertainty, we recognize the importance of providing access to up-to-date information. The situation that we find ourselves in remains extremely fluid, and it's important to have access to accurate and up-to-date information. So to that end, our firm created a microsite with updates on travel restrictions, quarantine protocols, operational status of government and immigration authorities, as well as concessions in jurisdictions around the world. And so I recommend I direct you to the site, and if you haven't done so, just kind of peruse it. There's a you may download a chart that literally goes jurisdiction by jurisdiction. It continues to be updated daily and currently covers over 160 jurisdictions. So a really great site to have kind of as your resources, not only for the company, your employees, but also their family members. We've noticed that this, of course, is impacting family members that would not otherwise be on your immigration team's radar. So moving on to the next couple slides here, our chart on, so slide 5. And before diving in maybe to the current state of affairs in the U.S. as far as immigration goes, I think it's important to take a look at how we got here, what transpired around the world before it really impacted the U.S. on the immigration. We started with some sort of travel bans, of course, first with China, then Europe. In March 17th, USCIS here in the U.S. Suspended in-person services such as biometrics appointment, green card interviews, naturalization interviews and ceremonies. And while we first witnessed visa appointments cancellations at U.S. consulate in China as early as January, it wasn't really until March 18th that the State Department suspended routine visa services around the world, which of course then impacted and aligned with much of the travel restrictions. So within the U.S., though, agencies have allowed some flexibility for employers, such as providing guidance on how to conduct remote I-9s, relaxing the wet signature requirement with a bit of a caveat. As you know, most of the applications made in the U.S. are paper-based and require a wet signature. They've extended some deadlines with respect to the filings of labor certifications, also known as PERM, though those were temporary. But perhaps the most significant concession was granting an initial 60-day extension to deadlines of certain RFEs, notice of intent to deny, and appeals. Of course, that sunsetted on May 1st, and on that day, the agency did extend for another 60 days through July 1st. So moving to the next slide, how has the pandemic impacted U.S. immigration? And while there's much talk about, as we were talking even earlier, about reopening the country, lots of discussion surrounding remobilization. In immigration, we still live in a COVID-19 restrictive environment. Travel bans and restrictions remain in place. Consular appointments remain suspended. And though there's talks of certain consular posts looking to reopen slowly in the summer and the fall, we'll likely see a heavy backlog when that happens. USCIS also announced recently that it will continue to limit its on-site services at least to June 3rd. And again, while USCIS has made some concessions with the wet signature, for example, it just hasn't been nearly enough to provide relief to employers and employees. For example, there's been no special COVID-19 relief for non-immigrants, meaning the folks that are here on a temporary visa whose status might be expiring. There's no added grace period because of COVID-19 and the challenges that may pose to file timely. There's also been no relaxation for green card holders who might have gotten stuck outside of the country with expiring re-entry permits. Compliance issues for employers also continue to linger as employees continue to work from home, work conditions remain fluid, and employers continue to onboard new hires virtually. So we'll dive into those in a little bit more specificity. And today's, the idea for today's conversation is really to educate you on the issues to watch out for that were triggered by COVID-19 and the risks that may present, and really inviting you to have that risk assessment conversation internally with the relevant stakeholders, your HR group, your legal team, engaging your immigration provider, as well as employment labor law provider, as a lot of those issues intertwine with immigration and labor law. So with that, I'll turn it over to Monica, who will talk about the latest on the presidential proclamation.
Thank you, Karine. So something I know many of you have been hearing about in the news is the latest presidential proclamation, and that does restrict some immigrant entry. So by virtue of this presidential proclamation, immigrant visa applicants are currently banned from entering the U.S. through June 23rd, although that could be extended further. And a practical way to look at the immigrant entry ban is to really see it as a ban on new immigrant visa issuances at consulates, particularly given the fact that consulates remain closed for anything other than emergency interviews, which can be difficult to obtain and don't typically apply to these types of immigrant visa applications. So if an immigrant visa was not issued by the time the ban went into effect on April 23rd, those individuals will not be able to enter the U.S. until the ban is lifted and consulates resume normal operations. And those, as Karine mentioned, could be subject to delays because of these ongoing closures. So many of the folks who have been waiting for their immigrant visa interviews, there could be quite some time until those are rescheduled, depending on that backlog. Fortunately, though, the ban is narrow, and it does exempt individuals such as U.S. lawful permanent residents, spouses and minor children of U.S. citizens, EB-5 investor immigrants, and then, of course, those foreign nationals who are seeking to enter on immigrant visas as healthcare professionals, because, of course, there's a great need there, as well as foreign nationals whose entry is in the national interest or furthers U.S. law enforcement goals. So that's a bit of a broader provision. Now, while that is restrictive and concerning to many, the most concerning provision of the recent proclamation is that it instructs Department of Labor, Department of Homeland Security, and Department of State to report in 30 days, which would actually be May 23rd, on whether the ban should be broadened to include non-immigrants such as H's and L's, as Kevin mentioned. So with that 30-day period coming to a close here in a matter of days, we highly encourage companies who wish to comment on the broadening of the ban to non-immigrants to take action now. There's a variety of ways that you could get involved in commenting on this and how it can impact your businesses. You can comment through government affairs practices if you have those internally. There's also many trade associations that are involved. Or you can reach out to us and we can help to provide ideas. We do have a government affairs team and we can assist in providing some other ideas on how to comment. A few other good options include the U.S. Chamber of Commerce or Compete America. So the president does have broad authority to ban the entry of immigrants, both temporary and permanent. And so that's, I think, one of the strategic reasons why this proclamation initially was focused on immigrant visa applicants only. Litigation options are thus narrower, and given the limited scope of the ban, are less compelling. So we really have not seen those. However, if the ban is broadened to include non-immigrants, litigation prospects will increase, and we do anticipate seeing those. So moving on to some other travel restrictions that we've seen over the last few months. The U.S., Canada, and U.S., Mexico travel restrictions still remain in place at land crossings. So those are currently still restricted to essential travel only, although that will sunset on May 20th, which is tomorrow, and there has yet to be another extension. However, as we've seen with a lot of the other rules, those are often extended at the last minute, so we are watching for news on that. Essential travel includes travel to work in the United States, travel to attend an educational institution, and travel for medical treatment. So pretty pretty broad standards there with regard to essential travel. U.S. citizens and lawful permanent residents, as well as individuals with travel documents, should also be exempt from these travel restrictions. And just as a reminder here, this only applies to land crossings and does not apply to air travel. So fortunately, with this ban still remaining in place, it does still allow for trade and business travel to continue, but it's important to note that many individuals could still be subject to additional screening at the ports of entry. And just remember that ports of entry are staffed by individual CBP officers, Custom and Border Patrol, and subject to the discretion of those officers at hand. And reports have been that the application of the rule has become more consistent over time. In the beginning, there were some officers that may have been inappropriately applying the rule to those who really should have been exempted, such as TN holders or L1 visa holders. But it seems to be that over time, this has become more clear in its application at the ports of entry. With that said, it still is important to speak with your TN and L1 employees and other employees who plan to travel via a land border during this time, just to encourage them to proceed with caution and maybe even consider providing them with a copy of the rule to carry with them and ensure they have all of their required travel documents on their person while traveling via those land crossings. And also remember that due to consular closures, visas cannot currently be issued in Canada or Mexico. So many of those individuals that are accustomed to traveling to Canada or Mexico to either go to the port of entry to apply for a TN or an L, for example, or for Mexican nationals go to consulates to apply for visa renewals. They cannot do that currently due to those consular closures. And then there is also the travel bans that remain in place for travel from China, Iran, Ireland, the UK, and the 26 countries of the European Schengen area. So this still remains in place, and they will remain in effect until they are terminated by President Trump. There are exemptions, which include U.S. citizens, lawful permanent residents, and their spouses and minor children, and some immediate family members, as well as foreign nationals whose entry in the U.S. national interest or whose entry would further U.S. law enforcement objectives. So again, pretty broad there. Medical research, for example, might fall into that category. But for everyone, health screening and quarantines may be required of those exempted travelers. So it's important that those travelers are aware of what the CDC guidelines are regarding quarantine and any sort of immediate in-home quarantine that may need to take place. Waivers may be sought for these, but as they are typically processed through consulates, and many of those consulates are closed to all but emergency applications, they could be difficult to obtain, but are worth exploring if necessary. That might be applicable to medical personnel, for example. And there's a test that would be conducted to demonstrate that there's no undue hardship, that there's no threat to national security, and that their entry is in the national interest. So things to consider there, ongoing issues with regard to travel restrictions. And now I'll turn it back over to Karine to discuss some issues for non-immigrant visa holders that remain in the United States.
Great, thank you, Monica. And so moving on to slide 12. Let me just see here as my computer freezes. This is where we are. Okay, so let's dive a little deeper here on the non-immigrant side of things. So these are the folks that are currently working for you in a temporary visa, and kind of some key issues to keep in mind and to remember. As mentioned, USCIS did not make any concessions with respect to a visa holder's ability to file for an extension, perhaps after the expiry of their current status. So and I mention this because in other jurisdictions outside of the U.S. Where government agencies may have shut down in light of COVID or for other reasons, there's been a little bit more broader concessions made. Here, because everything is filed by paper and the government remained open, the expectation is to still file timely. So extremely important to keep track of, as you would normally, of your workforce status, visa status, and ensure that you file those extensions before the expiration date. And I would even urge to file as early as possible. So it's important to remember that as long as an extension is filed timely, the individual can avail himself of that 240-day extension for authorized period of stay and work authorization. But again, the best practice would be to file early for a variety of reasons. And the earliest you can file is 6 months prior to the expiration date of the status. For those who have dependent spouses who are working on the L2, H4, or E3 work authorization, with the suspension of the in-person biometrics appointment, many of these applications have been delayed. And so, it's adding a lot more time to process these. And so the earlier you can apply, hopefully that will allow, when they reopen, to have those processed quickly. That said, we have seen USCIS approve some of these work permits without necessitating new biometrics appointments. They've been able to reuse previously captured biometrics. In addition, with the economic crisis that we face, with the directive from the administration to the agencies to review their programs to protect U.S. workers and stimulate the economy, it's likely that we'll continue to see an uptick in requests for evidence and possible denials. And so the impact there is, with increased processing time, suspension of premium processing, as I'm sure you're aware, all of that is creating certainly a bit of an uncertainty and anxiety for employees and employers alike. So the earlier you can plan and file for these things, it allows you perhaps a little bit more room at the end for a contingency plan. In the past, pre-COVID-19, in the event of a denial, where the employee had to depart the country, there was that opportunity to depart, wait for the subsequent approval, and come back in. Here, obviously, in light of the travel restrictions, employees might find themselves overstaying their period of stay and starting to accrue what's called unlawful presence. Another piece that's connected that immigration status impacts is driver's licenses. I'm sure you hear this from your employees quite a bit, where the driver's license validity period is tied to their period of stay, their I-94 card. And while we have this rule of 240 days, that it essentially automatically extends the status while the extension is pending, not many Department of Motor Vehicle departments honor that at all. And so what they might provide perhaps a 30-day extension that usually is not sufficient.
Karine, this is Kevin. Yeah. We're advancing the slides from you. We just want to make sure we're on the right slide. The slide we're on now called Issues for Non-Immigrants Temporarily Working from Home. Is that where we should be?
The one right before that, please.
Okay, Sara, can you go before that then?
Yeah.
Options for non-immigrants with an expiring period of stay?
Correct. Yeah.
Okay, and just let us know, Sara, to advance. We're trying to follow your narrative, but sometimes it's easy to get lost in that. Just tell us when to advance a slide. I'll go off screen.
Will do. Thank you. So the timely filing of extensions is important. There are certain visa categories that would normally travel to their home country and apply for the extension at the consulate, such as the E3 in Australia, H1B1 for Singapore and Chile, TNs, of course, with folks under NAFTA. And again, due to international travel restrictions, due to the visa consulates being closed, it's important. It's a good reminder to note that they too are eligible to file for those extensions here internally to avoid lapse in status and gap in employment. The change of status, folks, and this comes in often with respect to, as we're seeing more and more companies perhaps have layoffs, folks might have the opportunity to hop on the dependent status if their spouse is still working. Again, the timely filing of that is important. There's no specific grace period that was carved out for COVID-19 situations. USCIS does have the discretion to approve, a change of status or an extension if not filed necessarily right before the termination of the prior status in certain situations, but it is within their discretion. And so again, in pre-COVID-19 days, individuals might opt to just take a trip outside of the country, grab their H-4 visa stamp and come back in, because that would be a lot faster, and they would know right off the bat that they would be back in status. Other options, of course, is that folks are exploring is switching to the F1 student category and the B2 visitor category. I caution to proceed with caution on those. They're obviously highly scrutinized, and with it come a lot of issues to consider. With respect to change of employers, we get this question quite a bit for, your company might still be onboarding, right, and hiring new candidates. And so the question comes up where, well, what do we do if they're on H-1B? How do we handle that? When can they start, right? And those are all very good questions to have with all the respective stakeholders as far as setting expectations. Premium processing is not an option anymore. And in the past, we've seen certainly a lot of requests for evidence under this administration. And so historically, both the employer and the employee would decide to file this under premium processing to have assurances before the employee gives notice and before they're onboarded to know that the new H-1B had been approved. Of course, that's no longer available. And so that said, an employee on an H-1B may be eligible for H-1B portability and start on the receipt rule, meaning your company's H-1B filing. There are some risks associated with that, of course, if something were to go wrong with the H-1B petition. And so for folks who are currently employed, they may still want to wait to start until that approval is in hand. So that start date might look a little different than they used to, and from a company perspective, it's ensuring that still meets the business need. I as a parentheses, I do want to mention that we actually have been seeing change of employers get approved within a few weeks, which is, we'll knock on wood, hopefully that continues. But certainly that's something to think about. Now, if an H-1B candidate was laid off, and they're now coming to you and applying for a job, then obviously they would avail themselves of the portability rules. There is a 60-day grace period, not COVID imposed, but just from before COVID even, that they could avail themselves to a 60-day grace period and file that change of employer petition during that time. So it's everything is very fluid. There's a lot of different components to think about. As you can see, it's very much fact-driven, and it's also an analysis of risk sensitivity, as each company has its own way of approaching things. So really good to engage your immigration provider in those discussions and in setting expectations along the way. So next slide, please. With respect to working from home, right? This, as employers, move their employees work from home and in compliance with stay-at-home orders. This brought up some new issues for some temporary non-immigrant workers, particularly those who are on visas that where a labor condition application is required. And so the Department of Labor issued some guidance in the form of FAQs over the last few weeks to give us a little bit more clarity as to whether the home site was considered a work site and what notice requirement might be required. So those of you who file these, and you know that the labor condition application is specific to the employer, specific to the occupation. There are wage requirements and attestations to be made there, part-time versus full-time, and then there's specific work sites that are listed. And so if an H-1B worker, may be employed at a work site and the home has been considered a work site. And so as long as they're employed at a work site that's within the area of intended employment that was initially listed in the LCA, then there's no need for a new labor condition application. That was a big discussion that we had with clients initially. So as long as it's within the same intended area of employment and there's no material change to the rest of the terms and conditions of employment. So if there's no new LCA required, there's no H-1B amendment required, which is good news. But here's the twist. When stay-at-home orders were put into place, many of us had 24, 48 hours perhaps to react, right? And so you had students perhaps that were outside of the state, or maybe you had your employees on H-1Bs who were traveling, visiting friends, family outside the state, that their home, quote unquote, now became their parents' home or their friend's home, and that's where they had to work. And that potentially was outside of the area of intended employment and outside of normal commuting distance. And so in those situations, that would trigger a new LCA requirement for that new work site and therefore trigger an amended H petition. So something that, came out as of COVID-19 and of course of these travel restrictions. As many of you know, the labor condition application, there's a notice requirement for H-1B or visas that require an LCA. And the Department of Labor FAQ did not specifically address the posting requirement. That being said, arguably, you're supposed to give notice to the employees that have access to that work site. Well, arguably, the only employee that has access to the work site is the employee for whom you filed the H-1B, who also got a notice, a copy of the LCA. So that requirement has been made. But again, we've been having a lot of discussions, and we're finding that companies want to approach this a bit differently. So a good discussion point to have with your immigration provider. We threw in the STEM students here because, as you know, the STEM program for OPT does impose some reporting obligations and an updating of training plan when it changes. And the agency has confirmed that during this pandemic, students are not required to update their training plans, so employers are not required to update it, but the students should certainly report to their DSO. So that's a good reminder for that. And now I'll turn it over for the next slides to Monica to talk about the green card process during COVID-19 and issues to consider there.
Thank you, Karine. And so I'm moving on to slide 15. So what are the concerns and what is the impact to green card cases due to the issues that we're facing during this crisis? So specifically, PERM was an area of concern to many of our clients because it is so time specific, and there's deadlines that are required with regard to when PERMs can be filed. So Under current regulations, employers filing a perm labor certification application, as many of you know, must begin recruitment measures no more than 180 days before filing their perm application, and they must complete all but one of the recruitment efforts at least 30 days prior to filing. So in light of the crisis, the DOL did make a concession and stated that it will accept perm filings where recruitment efforts began no more than 240 days before filing, provided that the recruitment was initiated between September 15th, 2019 and March 13th, 2020, and that the perm was filed with the Department of Labor by May 12th of this year. So while that date has passed and the rule is no longer in effect, it was a valuable extension during this time when many employers were struggling with what the impact was with regard to their active perm cases. And as many of you know who work on perm filings, that is a pretty lengthy timeline. A lot of time, effort, and resources are invested into perm recruitment. So this is a nice concession that did help some of the active perm cases for clients. Something else that's really important to consider is the notice of filing, otherwise often referred to as the internal posting. So under regulations, that notice of filing must be posted for at least 10 consecutive business days and completed within 30 days before the date which the employer files the perm with Department of Labor. It's also subject to that same 180-day window. So given that a lot of companies are closed and their physical offices are not open for business at this time, it's really important to consider when can you post your internal posting or your notice of filing again. So it must be posted for 10 business days and clearly visible and unobstructed while posted, and must be posted in conspicuous places where the employer's U.S. workers can readily read that posted notice on their way to or from their place of employment. So at this time, if your office is closed, the guidance is very clear that if you do not have anyone in your office at this time, employers should not be posting their notice of filing. There's no relaxation for that physical hard copy posting. They're not allowing for, or they haven't specifically addressed allowing for electronic posting. And so the conclusion is that it would not be advised to post those notices of filing in offices that remain closed during COVID. However, as many of you are planning for remobilization right now, it's important to consider what to do, as many offices are opening slowly in small controlled batches. And so at what point is it okay to start posting that notice of filing? Also, a lot of employers are considering keeping a portion of their workforce at home indefinitely if they're not on-site critical. So this is a really important consideration with regard to your perm filings, and there's not really a specific threshold level of when a work site is open enough to begin physically posting, or at least it hasn't been specifically addressed during the crisis yet by Department of Labor. However, we've turned to some other guidance that may shed some light onto the factors that could be considered when making this determination. So Department of Labor will require the employer to demonstrate that they were open for business during the days that their notice of filing was posted. So a few factors that we can turn to determine if an employer is open for business can include whether the employees were working on the premises and engaged in normal business activity. There's no specifics there as to how many employees are on site. They may also consider whether the worksite was open and available to its clients and or customers, if applicable, as well as to its employees, and whether its employees had access to the area where the notice of filing was posted. Now, this is an important practical consideration because most often employers will post their notice of filing in their break room. And if per social distancing requirements, your break room is now closed, it's really important to start thinking about where the best place is to move those notice of filing postings to make them more visible. Perhaps it's the hallway where employees will be passing through, but it does need to be somewhere that's visible even amidst these anticipated social distancing requirements. So when you do decide to resume posting of the notice of filing, you really should ensure that you have sufficient documentation to establish that the days it was posted were in fact business days. So evidence that goes to all of these factors, and clearly document that and keep that evidence in the event of an audit so that you can demonstrate that those should in fact be considered business days for your company. And of course, as Karine mentioned regarding non-immigrant visa issues, this is also very fact specific and a difficult decision to make. It's definitely a risk sensitivity analysis because the perm process is so critical to many of your employees, and for some there may be groups where it's critical to them being able to continue to even extend their non-immigrant visa status depending on how far along they are in the process. So there's a risk analysis to be made there, and we encourage you to reach out to legal counsel to assist you in navigating those decisions. But you also, one other pointer is to maximize effectiveness by also posting through in-house media, even if you don't typically do so. So an electronic posting on any of your in-house media is encouraged during this time, even if you didn't do that before. So with that, I will be moving on to slide 16, which is actually an introduction. I'll hand it back over to Karine. We're going to speak to the impact to immigration issues with regard to wage reductions, furloughs, and layoffs during the crisis. So I'll hand it over to Karine.
Thanks, Monica. So we're now on slide 17. And so, we're seeing, of course, an increase in companies taking some cost-saving measures, whether it's reduction of hours, reduction of pay, furloughs, or layoffs, and that too triggers the need for an in-depth analysis and discussion, both from an immigration perspective, and again, this is where the labor law component comes into play as well. So let's talk furlough versus layoff for a moment. And we saw furloughs happening as well back in recession days in 2008, 2009, and it takes on a different meaning than layoffs, where furloughs usually there's an intent. There's a temporary pause of employment triggered by the employer. There is an anticipation that the employee will resume work at some point. In fact, in some situations, employees continue to receive employee benefits, but the employment relationship, if you will, has not necessarily terminated. That does, however, still trigger some important immigration compliance considerations, particularly for those who, again, we go back to the same, the trio of visas that require that labor condition application. And with that LCA, there are wage obligations that were made, or that the employer attested to maintaining. And so any reduction in hours and reduction in pay could likely trigger the need for a new labor condition application and therefore an amended petition. So that's from the employer side, making sure that the employer remains in compliance with its wage obligations there under Department of Labor regulations. On the employee side, of course, if that amended petition isn't filed, there could be some violation of non-immigrant status, which could impact them down the road when they go and obtain a visa stamp at the consulate, when they apply for green card applications. And so, we talked a little bit about, okay, well, if an amended petition is required, we talked about the H-1B having a grace period of 60 days. That grace period only applies for terminated employees. So really, for folks on an H-1B, before they can begin working in that reduced pay, reduced hours schedule, the amended petition would need to be filed. And then, of course, then they can likely avail themselves of portability rules and start on the receipt rule. But you may have, you know, employees who are on a different visa category that where portability is not available, and yet an amendment would be required nonetheless to ensure that they maintain status. And for those folks, the amendment would actually need to be approved before they began working under the changed conditions. And so, of course, without premium processing, with lengthy processing time, right, this might take a while before they can actually resume back to work. Of course, for the folks who are on an LCA, the reduction in pay does trigger an analysis to ensure that the employer is still meeting prevailing wage requirements and obligations there. One thing that's come up in some of our discussions with clients as we kind of help them navigate through this and how to set this up and ensure that they're compliant, they remain compliant, is the fact that we have to be, you know, there needs to be a careful assessment of how all the employees that are similarly situated are being treated. Because if there is if the company decides to treat U.S. workers differently than the H-1B, that could be viewed as treating U.S. workers differently and could lead to some wage and hour investigations. And Monica will talk a little bit more about that later. And so again, it triggers a risk assessment, and the discussion does include, you know, HR, in-house counsel, perhaps employment counsel on the wage and hour situation, and immigration counsel whenever possible. Moving to the next slide on termination, if in fact there is a layoff and the employee is terminated, it's a good reminder that for folks who are on H-1B, H-1B1, E3s, those that, again, the trio of LCAs, there must be a bona fide termination, and that's required to ensure that the employer's wage obligations are terminated, so that you're not subject to back wages down the road. So there's notices not only to the foreign national employee, but to USCIS as well. Those three visa categories plus the O1, so if you have folks on extraordinary ability visa, the O1, there must be an offer for return transportation that's provided to the employee. Now, in the past, a lot of our clients would say, okay, we'll give them a ticket. We'll pay for the ticket. Of course, with international travel suspended, this would not be possible right now. And in order to meet that requirement, companies would have to provide the value of that return transportation. Here, because it's a termination, the 60-day grace period for folks on H-1B would be available. And so, again, as we mentioned before, if they had been laid off, they would be able to avail themselves of that 60-day grace period potentially. And so with that, I'm going to turn it over to Monica for slide 19.
Thank you, Karine. So with regard to the impact of layoffs or furloughs to the perm process, there's a lot of things to consider here. So it's important to remember that layoffs of a U.S. worker in the area of intended employment and same or related role as the foreign worker will require the employer to hold the perm filing for 6 months or notify and consider all potentially qualified laid off U.S. workers. So it's important to remember here that not all layoffs will subject an employer to halting the perm filing for 6 months. The perm regulations define a layoff as an involuntary separation. So it's something to think about whether or not this would be the case if your employees are departing the workforce. And under this definition, a furlough or a reduction in hours would not likely result or rise to the level of the definition of a layoff, but there's some important things to consider and some challenges that you may face as a result of furloughs as well. Furloughs could lead to challenges such as audits, denials, or something called supervised recruitment, where Department of Labor would be closely monitoring and guiding you through step-by-step of the recruitment process for perm. And regardless of your layoff analysis, Department of Labor does pay close attention to corporate layoffs, and they're known to review warn notices and news sources to determine if a company has recently laid off workers. So if there's a warn notice as a result of a layoff, it's very important to consider this carefully and determine if you'd want to consider halting perm for a period of time, and consult with your immigration counsel about this. The agency also pays close attention to industry-wide layoffs, and they may call into question an employer's attestation that no minimally qualified U.S. workers have been identified after filing the perm, when the current state of the economy may suggest that many U.S. workers with that skill set are currently out of work. So that's really important to consider when you're determining whether to proceed with perm filings for some employees following a layoff. It's also important to consider the climate and whether there could be any negative public relations as a result of proceeding with perm in light of the climate. So when you do decide to proceed with perm recruitment in a climate of high rates of unemployment, it's also critical to ensure that you're closely considering all U.S. worker applicants, conducting diligent interviews of those applicants, and carefully documenting whether they meet the underlying recruitments of the perm position, so that you're prepared in anticipation of a perm audit. You'll have to demonstrate that those individuals do not meet the requirements of the perm role or could not come up to speed on those requirements in a reasonable period of time, and just be prepared to document and explain that to Department of Labor in the event of a perm audit. So with all of these challenges in mind, it might be worth considering and evaluating other green card options. Some of those include the EB1 category for extraordinary ability, or EB1 outstanding researcher. Many of you may have individuals that could qualify for either of those. A lot of the engineers that have PhDs may very well qualify for EB1 outstanding researcher, depending on their background and roles. Or there's the EB2 national interest waiver, or Schedule A, for individuals with exceptional abilities in sciences, arts, or businesses to consider. So moving to slide 20, in the interest of time, this is just a reminder that compliance is so critical right now. If we remember the 2008 recession, there was a 52% increase in Department of Labor enforcement actions. And so there's really no reason to believe DOL will behave any differently now when the economy reopens. If anything, we could see even higher percentage of enforcement actions when everyone resumes normal business. So it's really important to make sure that your compliance house is in order. Audit your LCA public access files. That's always a low-hanging fruit for a Department of Labor auditor. So conduct those audits, get that in order, and just consider, what is your program's vulnerability to employee complaints? A lot of DOL investigations rise out of whistleblowers or H-1B employee complaints. So it's important to just think about employee relations and how issues in the immigration program are being addressed, and just consult on those issues with your immigration counsel and your general counsel's office when considering any of these workforce restructuring and how everything is being messaged and addressed with your workforce. And so moving on to slide 22, just a quick recap on flexibility in I-9 verification requirements. So DHS did issue interim guidelines for remote I-9 verification during the emergency. And this is very helpful because it does allow employees to complete, it doesn't allow employers to complete Section 2 of Form I-9 or Section 3 virtually. So that could be done via reviewing documents presented through fax, email, or even a virtual platform. And then when normal operations resume, employers have to physically inspect those documents within 3 business days for any I-9 completed remotely. It's important to think about this strategically, if that makes sense, versus perhaps using designated agents to complete the I-9. And remember, logistics are important because you will be required to review all of the remote I-9s within 3 days after close of the national emergency. Lastly, E-Verify did not relax their 3-day deadline for initiating an E-Verify case. They did provide guidance on what to do if for some reason you are late in completing that, but the advice is to still abide by the 3-day deadline. They did extend the time frame for resolving tentative non-confirmation responses. And just a really important reminder that employers should not be taking adverse action against employees whose E-Verify cases are in interim status, especially right now. So there's a lot of issues we could dive into deeper on that, but just in the interest of time, I'll go ahead and close and see if there's any questions.
So there are a lot of questions, as you can imagine. So I'm going to try to take these in the order in which they came. So let me go ahead and start off. Here's question 1. So there's a lot of questions. So we may have to go through these fairly quickly for our host. So the first question, what happens to an E2 visa holder whose I-94 is expiring, but visa is still valid for a few more years and would normally travel?
That's a great question. I can take this one. This is Karine. Yeah, fantastic question. And you're right. Normally, they would fit into that category of normally they would travel, depart, come back in, get another 2 years. And so I think as the situation, you know, again, depending on the facts and as the situation kind of relaxes as far as travel, that might be something we need to look at to see what our options might be. Is travel anywhere possible? You know, oftentimes living close to the border here to Mexico, we look to Mexico quite a bit to get that new I-94 card renewed. But if that's not feasible, and there's a lot of that goes into that, right? The travel bans, the travel restrictions coming back, any quarantine issues going into that country, the person's comfort level as well, quite frankly, right? Especially if there's family. So if that is not feasible, there is always the option of filing an internal extension with USCIS to make sure that they stay in status.
Jumping to our next question. I'm an F1 visa holder and my OPT work permit is expiring. Do you anticipate that USCIS will provide any extended grace periods beyond the 60 days if it is still unsafe to travel?
Hi, Monica here. I can take that one. So, you know, it's not anticipated that they're going to relax the grace period at this time. Specifically, they haven't addressed. There's been a lot of questions raised on that. We have yet to see that come out, although there have been a lot of rounds of FAQs related to F1 OPT. And each time that they issue a new set of FAQs, we do see a lot of new guidance, but at this time we haven't seen anything with regard to that provision specifically. But it has been raised by stakeholders, and is an important question to continue to monitor.
So a caveat on some of these questions, right? So, you know, I'm sure it's, and Karine, weigh in here if you like. We're releasing information for you to hopefully make informed decisions. Obviously, some of these are going to be customized answers, and for those, and every answer is going to be different depending on your particular circumstances. So always advisable to check with your labor attorney. Fragomen won't say this, but I will for them. So Fragomen is the global leader on immigration, and so you know, certainly get in touch with the two hosts and see if they could help you out offline. But let me go through some of the other questions. Are there any guidelines or exemptions for citizen spouses living in U.S. who have a green card restriction removal application coming up? An application to renew apply for restrictions on green card.
Can you repeat that again? Are they in the U.S.?
Are there any guidelines or exemptions for citizen spouses living in the U.S. who have a green card restriction / removal application coming up?
This is Monica. Perhaps they're addressing removal of the condition. I'm thinking.
Yeah. Yeah.
And so far there have not been any extensions with regard to the removal of the condition, as those applications may be filed internally with USCIS, and USCIS is still accepting those applications.
Okay, next question. How are ongoing H-4 visa applications for dependents of an H-1B employee impacted during the H-1B transfer to a new employer?
That's a great question. The H-4 status is dependent on the principal spouse H-1B status. It is not tied to employer A or employer B, right? So, you know, you can take the view that if once the employment ceases to exist with employer A, well, we need to take the necessary steps to immediately file, and if we are able to avail ourselves of that 60-day period, file the H-1B change of employer, and then at the same time file the H-4 extension. Or if that H-4 is still valid, the H-1B could go by itself, but then you'd have to track both expiration dates together. So the best practice would still be to group them together, but the H-4 is not tied to an employer specifically. It's tied to whether or not the principal spouse maintains valid H-1B status.
Okay. Is there any issues or delay on H-4-EAD application, which is in progress?
That's a great
so
question.
We talked about, oh, sorry, go ahead.
Yeah,
go ahead, Monica, yeah.
The big factor there is the biometric requirement and those being delayed right now. So if biometrics had not yet been completed, it's likely that we could see delays there, and Karine, I'll allow you to add to that, but yes, we could anticipate delays.
Okay.
Yeah,
I think we've covered this, but just in case, we have someone else who asked, can you speak to green card renewal? Not imminent.
So green card renewals, if you're in the US, you can file your I-90 and renew your green card. I don't know if that's the question that was intended, but
so, you know,
that being said, I guess I should add, you know, to the extent that biometrics appointments are necessary, to the extent that there's, depending on the green card application, that an interview is required, that will cause delays, right? Because again, at least until, you know, June 3rd, and then because USCIS has extended the suspension of any in-person services. So we'll have to see what that looks like after June 3rd.
You know, one of the things in going through this presentation, first of all, it's one of the most technical presentations we've had on COVID-19, but what's very evident is how fluid this is. And so, you know, and this is, you know, I don't think people understand, you know, the Fragomen's role in national, you know, immigration discussion. I mean, you really are the leaders. And so for a national firm like Fragomen to say, you know, we think this is happening, and it seems to change, you know, day to day, hour to hour. Is that observation correct, or are things starting to clarify a little bit?
I mean, 100%, right? If there's a takeaway for today, things remain extremely fluid, not only in the US, but in other jurisdictions. And as soon as we start talking global mobility, right, whether it's for personal reasons or employment related, we must take in consideration all of the jurisdictions that come into play. So it remains extremely fluid. And there's a lot of risk, right? We talked a lot about risk assessment during this hour, and that's tied with compliance. So I think that would be, you know, the main takeaway from today is those things. And therefore, you know, what we say today might look different tomorrow. It might certainly look different in the next 30 days. And then each fact, each situation, there's not a one size fits all. We always are asked, you know, can you provide an FAQ? Can you give us this? It's unfortunately, the facts do matter in the analysis, and then the discussion as far as, you know, risk sensitivity, the comfort level everybody comes into in the ultimate decision. And
I think in the past where you might have been able to figure it out, in today's climate, I just don't see that happening. So whether you're an employee or an employer, you're going to need some Sherpas. And, you know, certainly I've always looked to Fragomen. Karine, I know you guys must be extremely, extremely busy right now. Let me ask you a very direct question. Are you even accepting new clients now?
Absolutely. I mean, look, our role in this space is to help everyone, whether it's an employer, an employee, their family members, navigate through these challenging times. So we are available, absolutely. If we, for some reason in San Diego, cannot assist, we have offices throughout the U.S. This is, you know, a federal law, and therefore we've got the resources to assist you. This is such critical time for people, and it's a personal journey. You know, it's people's lives. It's their children are going to school, and I'm an immigrant myself, and I remember going through this and thinking, oh my gosh, do I have to go back to France after this? Like, not that it would be a bad thing, but you're so used to living here. This is your life, and so we take that to heart. We're here to help. We're here to at least have the discussion. There may not be a good solution at the end of the day, but we're certainly happy to help. And I was going to mention that for those questions that we weren't able to answer, we're happy to, if you want to send those over to us, we're happy to connect with the folks and provide them with some responses.
And so we'll have this presentation. First, we'll have the slide deck available on our resource page at techsandiego.org, probably within minutes of ending the webinar. And it'll also be on YouTube, so you'll be able to hear the narrative that our speakers gave. Karine, Monica, wow, this was one of the most informative webinars we've had. You were able to relay a lot of information in a short amount of time. Again, if you're trying to do this on your own, you're going to need some help on this. So whether that's Fragomen or someone else, suggest you seek some good guidance on this, and we will all get to the other end of this. And again, I just want to thank Monica and Karine for spending your valuable time on this. Fragomen, we don't pay Fragomen to do this. They're a member of Tech San Diego, and they do this to help the community. So I want to make sure to thank both of you for coming on and sharing your knowledge.
Thank you. Our pleasure, and thank you for hosting. Yeah.
Okay, and your contact information is in the slide deck. Your contact information, correct?
Correct. Our email will be on that slide deck that we provided to share. Mm-hmm.
Fantastic. We're going to go ahead and end this webinar, and we will see everyone in the near future. Check techsd.org for future webinars, and always check our COVID-19 resource page. Sara is our events manager who does this. Sara, thanks for everything. Is there anything else that we need?
If you're interested in, if you're a CEO or a leader in San Diego and you're interested in joining an all hands COVID-19 coalition meeting, we will be meeting at 8 a.m. on Thursday this week for an all hands on deck meeting. And if you're interested in joining the roundtable discussion, visit techsandiego.org and click on the event calendar to find out how to register for that event.
Fantastic.
Thank you so much.
All right, thank you. Goodbye, everyone.
Bye, thank you.
Thanks, everyone.